Hi, everybody. It's Leslie with the New Mexico Small Business Development Center, and I'm here today with Ian Alden. He is a licensed practicing attorney. I hope I got that right, Ian, here in the state of New Mexico. And this is a tricky topic. It's a long title. Bankruptcy Subchapter V, how the new guidelines will affect you and your business. So I want to turn it over to Ian. He's going to walk us through all this kind of trickiness but relevant information that we need. So Ian, if you'd like to take it away.
Hi, everyone. Good afternoon. I'm glad to be here with you again for today's workshop. I'm happy to go through the materials and talk about Subchapter V Bankruptcy, how it differs from the other bankruptcy titles and chapters, and how it pretty uniquely can be used for your business. Before we get started, I want to go through just a few COVID-19 related resources. Make sure you're aware of the resources at hand to help keep a COVID safe workplace. This is especially important as we all start returning to work and the work from home arrangements start to fade. So it's important to know your resources and make sure you are tapping into them so that you can maintain a COVID safe workplace. And yeah. Just a few quick notes. Your microphone should be muted automatically, but if for whatever reason yours turns on, please make sure you mute it. Please make sure your Zoom ratio is set to fit window if it isn't already. That's so that you can see all of the slides that I'm going to be showing you. We'll be using the Q&A function to take questions, and I'm going to be taking them throughout. So if you have a question, just jump right in and ask one. But please use the Q&A function. I'm not going to be monitoring the chat window. Q&A is a separate thing right at the top of your screen. You should see it. The slide number you can see in the bottom right-hand corner. Please write down the slide number that your question relates to, especially if you ask your question later. I want to make sure that I know where to jump back to. So before we get started, I just want to draw your attention to a few of the other workshops and training offerings the SBDC is offering. We've got one on May 18th, Google Search Secrets of the Pros. May 19th, there's quite a few. E-commerce, starting a business. May 20th, understanding employment contract. I'll be leading that one. So be sure to check in with the SBDC regularly. They've got a lot of great workshops that are going on free to you. So be sure to check in regularly. So the first thing we're going to talk about, really, we're just going to go over bankruptcy in general and look at some of the basic kinds of bankruptcy that people are often familiar with but don't really understand all that well. It's actually important to understand what these other forms of bankruptcy are to understand what Subchapter V is, because Subchapter V is relatively new. It came about in 2019, and it's kind of an extension of a few different types of bankruptcy. So we're going to cover everything and then circle back to Subchapter V, and then we're going to explore some scenarios in which Subchapter V may or may not be useful for a business. But just to start, bankruptcy, I'm sure you're all familiar with it. It's a tool that, if used strategically, can help struggling businesses and their owners regain financial solvency. The idea being that if you have more in the way of debts or debt payments than your cash flow will permit you to repay, and you're just at the end of the road, bankruptcy is meant to help you right the ship and get into a better place financially. Bankruptcy, it's a tool that tries to balance the needs of the debtor with the interests of their creditors. So it's not a tool where, you can just say, I declare bankruptcy in the style of The Office and throw up your hands and the creditors walk away with nothing. It's very often the case that the creditors are going to get at least partial repayment, if not full repayment, through the bankruptcy. So it's not as simple as walking away from your debts, but it does let you, in many cases, cram down, write off, or discharge altogether a lot of debts. So we're going to go through some of the different types of bankruptcy and how they can be used in different situations. Starting with Chapter 7. Now, Chapter 7 is the most commonly understood type of bankruptcy. It's when you think of bankruptcies in terms of liquidation or reorganization, which are their two primary goals, this one is a liquidation bankruptcy. The idea being that you put all of your assets except for the ones that are exempt. We'll talk about exemptions in a little bit, but you put all of your assets into a big pot, you liquidate it, or rather the bankruptcy trustee does. They sell what they can sell. They pay the creditors what's available, and then any debts left over after that liquidation process are typically discharged, with a few exceptions. There are some non-dischargeable debts that we're going to see throughout the bankruptcy code and different bankruptcy types. Student loans. Many people know student loans are non-dischargeable, except in rare instances where the debtor can convince the court that they will have an undue hardship if they have to repay the loans. It's a very high bar legally to cross, and so student loans are typically thought of as non-dischargeable, or at the very least, very difficult to discharge. Other non-dischargeable debts include trust fund taxes, aka payroll taxes. You know, if you withhold taxes from employee paychecks and then don't pay those over to the IRS, those are typically non-dischargeable. Also, debts arising from willful or malicious injury to another. If you harm someone maliciously or willfully and then they sue you and get a judgment, you typically can't get that judgment discharged in bankruptcy. The courts just aren't going to let you. So bankruptcy has some debts that are just non-dischargeable across the board. And so it's important to keep that in mind. But Chapter 7, it's basically it's the most immediate of the bankruptcies. Different chapters, 11, 13, subchapter 5, they all can drag out for some period of time, sometimes as long as 5 years. Chapter 7, if you qualify for it, it's an immediate discharge of your debts. So once everything goes into the pot, it's sold, it pays off the creditors to the extent it can, the remaining debts are discharged, and that's it. You walk away. Average time frame for a Chapter 7 bankruptcy is maybe 4 or 5 months from beginning to end, from the date you file to the date the discharge is entered. So yeah, it's quick, which is nice. It also results in an immediate discharge, which is nice. The problem with Chapter 7, obviously the pro is there, a full discharge of debts. The cons, there's a few. Secured property, for example, houses, cars, that you buy with a loan, purchase money instruments, mortgages, things like that. Property secured by debts will just revert back to the creditors if the secured debts aren't assumed. And by assumed, it means that you agree to keep paying it even after the bankruptcy. So if you have a house that's secured by a mortgage, there's a good chance that house is going to go back to the mortgage holder as part of the bankruptcy process. You wouldn't be able to keep it, for example, if you wrote off the mortgage. Secured property can revert back to the creditors. Again, it's a liquidation bankruptcy, so assets not covered by bankruptcy exemptions will become part of the bankruptcy estate and used to pay creditors. The last con, which is a big one, is means testing. Means testing is why a lot of even my own clients don't qualify for Chapter 7. Let's see if I talk about it here. No. Means testing, back in 2005, Congress radically changed the bankruptcy laws and imposed a means test, which means if you make a certain amount of money, or if you have even made a certain amount of money in the past and can't show that that income has somewhat permanently changed, if you make more than the caps set by Congress based on factors such as where you live, your family size, etc., you don't qualify for Chapter 7. And if you don't qualify for Chapter 7, as an individual, you tend to default to Chapter 13. As a business, you tend to default to Chapter 11. But Chapter 7 is getting increasingly hard to access. And so, there's bankruptcy reform laws that are being floated that will change that and roll back some of those prohibitions, eliminate means testing. But that's the biggest con of Chapter 7, is that fewer and fewer people are eligible for it, especially because the standards of the means test don't change nearly as much as wages seem to. So that's probably the biggest one. Chapter 13 is the alternative, the default alternative for individuals to Chapter 7. It's often called a wage earners plan. And we're talking about this because this is actually going to factor into Subchapter 5. So bear with me. I should get through this section pretty quickly, and then we'll turn to Subchapter 5 and what it means for you. But Chapter 13, it's a wage earners plan. Basically, you take your debts, the bankruptcy trustee will take all the debts, pool them together, you figure out a repayment plan, and then you as the debtor pay it for a period of between 3 and 5 years, depending on your financial means and the debts. You're paying substantially all of your net disposable income, which is burdensome to say the least, because it doesn't really leave you anything with which to grow or get some financial security. You can't really put much into savings when you're on a Chapter 13 plan because everything's going to the creditors. So you pay for a period of 3 to 5 years, and then after that period is elapsed, any debts that haven't already been paid, they get discharged by and large, unless they're non-dischargeable in the same way as those Chapter 7 debts are. There's a few caveats for what debts are dischargeable in Chapter 13, especially if you've had a Chapter 7 bankruptcy in the preceding few years. Doing a Chapter 13 right after might make some of those other debts non-dischargeable, but Chapter 13, as we discussed, it's the wage earners plan. You're eligible for a Chapter 13 bankruptcy if your unsecured debts are less than 394,000-ish, 395,000. And if your secured debts, again, those are the debts that are backed by collateral, a house, cars, etc., are less than around 1.2 million, subject to some other limitations. So Chapter 13 has its own limits on who qualifies. They're far less odious than Chapter 7, which caps out at around $50-some thousand for a single filer in New Mexico. The means test, it's pretty low and prohibitive for Chapter 7. Chapter 13, more people tend to qualify for. But maybe you find yourself in a position where you can't pass the means test for Chapter 7, and your debts are too large for Chapter 13. Then, as a matter of last resort, you might look at Chapter 11, which we'll cover in a minute here. Chapter 13, just so you understand the criticisms, and these do apply to some extent to Subchapter 5, which is, again, why we're talking about them. But one of the big criticisms of Chapter 13 is that people who are already struggling financially, when they enter into a repayment plan, are then committed to spending all of their net disposable income for 3 to 5 years on that repayment plan. So it doesn't afford them any breathing room to get into a better place financially, assuming that their income stays steady and their debt, obviously they don't incur new debt during the repayment plan, because you need permission from the court by and large to get new debt when you're on a repayment plan. But assuming that all those things hold steady, maybe they can finish the plan in 3 to 5 years if nothing changes for the worse. But for a lot of debtors, things do change for the worse over the span of 5 years. Who knows when a pandemic will hit and you'll lose your job. So a big criticism of Chapter 13 repayment plans is they fail. And if they fail, there's no discharge of debts at the end of the plan. No discharge of debts means, why did you declare bankruptcy in the first place? You just paid, X number of years of money to these creditors, and then they can still go after you for the remaining balance, and you still have a bankruptcy on your credit history. So Chapter 13, there's a lot of valid criticisms that are also tied to the means testing of Chapter 7, which is that a lot of people who should be able to use Chapter 7 just can't. So pros and cons. If you're ineligible for Chapter 7, it's probably an option for you unless your debt is too high. Another good pro is that you can keep secured assets while trimming the unsecured parts of the loans, which is good for underwater loans. There's some limitations to this, like there is for everything in the law. The law is just rife with limitations, but for a lot of people who are underwater in their loans, Chapter 13 might be a good option to let them pay the secured part, which is the value of the property itself, while trimming off the excess portion, which is everything above the value of the property. So that's a nifty perk of Chapter 13. The cons we talked about, payments are often so large as to prevent the debtor from becoming more fiscally solvent and sound. You can't generate huge savings. The reduction in income can complicate and prevent completion of the plan. If your wages drop, you suddenly need to have your net disposable income recalculated, which can take time for you and the trustee to do. So it really can complicate the completion of the plan. And obviously, it just takes a long time. 5 years is a long time to be paying off these debts, whereas Chapter 7, you can be discharged immediately. I'm not advising people to do this, but I have known people who have deliberately lessened their income by resigning or going part-time or something for long enough that they suddenly pass the means test of Chapter 7. I mean, compared to Chapter 13, doing something like that might end up being a better financial option for you. I can't advise people to do that, but I've seen people do it out of desperation. So that's Chapter 13. And then we move on to Chapter 11, which is kind of at the heart of what Subchapter 5 is, because Subchapter 5 is the subset of Chapter 11. Chapter 11 is a reorganization bankruptcy. It's most often used by businesses. It was designed to let businesses renegotiate their debts with their creditors, possibly enter into some forced cram downs with those creditors if the creditors aren't agreeable, but by and large, they have to agree in a Chapter 11. And then it lets the business come out the other side in a better fiscal position. You hear about a lot of businesses, large corporations, using Chapter 11 to trim down their debts. I'll give you a common example, Toys R Us, which might not be a great example because they ultimately converted to Chapter 7 at some point. Think large corporations, they use this when their financial picture has changed, maybe the internet's eating into their business and they just need to rework their debts and come out in a better position so that they have better cash flow and better more access to cash on hand to use for retooling their business. Individuals can also use Chapter 11, particularly if they're ineligible for Chapters 7 and 13. Chapter 11 for an individual is heinously complicated and expensive, and I've personally never seen it work for an individual. I've heard of cases where it works for individuals, particularly high net worth individuals who have some temporary cash flow problems, but by and large, it's possible to be caught in a trap where you're ineligible for Chapter 7 because of your means testing, ineligible for Chapter 13 because the debts are too high, and ultimately ineligible for Chapter 11 because you can't get the creditors to agree to a plan of reorganization. There are some glaring holes in the bankruptcy code, which current proposed laws are trying to fix. But just know that Chapter 11 can work for businesses and individuals. Now, the ideal end result of a Chapter 11 is that the debtor and the creditors agree on a reduction of debts and a new payment agreement that'll let the debtor continue operating. It's called a plan of reorganization. It has to be negotiated, and in a Chapter 11, that's a complex process. The trustee will appoint a committee of creditors for the unsecured creditors so that they can band together and vote on approving or declining a plan of reorganization. The creditors can submit their own plan of reorganization in a Chapter 11. So if they think the debtor has assets that should be used a certain way and the debtor isn't willing to propose it, the creditors can. This all goes in front of the trustee and ultimately the court, who would have to approve the plan of reorganization. There's some reasons why a plan of reorganization might not be approved, particularly if creditors' interests aren't being seen to properly, or very commonly, if creditors stand to get more out of a Chapter 7 liquidation bankruptcy, which we just talked about, than under the Chapter 11 plan of reorganization, that plan will fail. One of the rules of Chapter 11 and Subchapter 5 is that the creditors have to ultimately be in a better position in recovery than they would be if there was simply a Chapter 7 liquidation. That's possible because Chapter 11's payment can be made over time, same with Subchapter 5. And so you have future income to bargain with in a reorganization. So whereas with the liquidation, all you have to offer is the assets you currently have. With chapters 11 and subchapter 5, you can be playing with 3 to 5 years of income. Same with chapter 13. There's the intersection. So in a chapter 11 context, creditors often come out better than in a chapter 7, particularly if the business can right the ship. But if the plan of reorg is going to fail because there's no true plan to reorganize and the problems that are plaguing the business aren't going to be addressed, chapter 11 can fail. Now, chapter 11, it's also the most expensive form of bankruptcy for a few reasons. The bankruptcy counsel fees are quite onerous. It's very complicated. The trustee has quarterly fees. Let me see if we talk about those here. Quarterly fees, the trustee gets paid for their services according to a chart that bases the trustee fees off of distributions that the bankruptcy estate makes. So, the bankruptcy estate collects assets from the debtor, distributes out to creditors, et cetera. And, based on distributions, the fees can be up to $250,000 a quarter, which means up to $1 million a year in trustee fees. The debtor also typically has to pay the expenses of the creditors committee. The debtor has to pay their own attorneys. The debtor has to pay the filing fees for chapter 11, which are quite high. And then of course the debtor ultimately has to pay what it's obligated to under the plan of reorganization. So chapter 11 is very expensive. It's also very complicated, which is why a lot of small businesses just can't navigate it. It's expensive, it's time consuming, it's complicated. There are extensive disclosure requirements that have to be made by the business, many of which need to be made on a monthly basis, which takes the work of sometimes multiple accountants to do. I mean, these disclosure forms are onerous. And so chapter 11, what was meant to be kind of a catch-all for businesses, really ended up being a tool of large corporations and a huge disadvantage for small businesses. Which is going to bring us, one other con to talk about. Businesses will often fall into the hands of a trustee or a receiver and out of their owner's control. So if the business has assets that need to be preserved, or if the business is being mismanaged, or if the business owner is potentially committing fraud or mismanagement or what have you, there's a litany of reasons. The bankruptcy trustee might take the business out of the hands of the business owner and put it in the hands of a receiver. And that business might not revert back to the owner once the plan of reorganization is approved. So you could stand to lose your business, or at least lose control of it in a chapter 11 context. Which brings us all to subchapter 5. Subchapter 5 was created in 2019, August 2019. It's actually created before COVID, which was just kind of serendipitous timing, I guess. But it was meant to address some of the glaring holes in the Chapter 11 bankruptcy process, particularly the cost and the complexity. This was passed, and this is just some political context for you. This was still passed when Democrats held the House and Republicans held the Senate and the presidency. And so this wasn't intended to be a sweeping reform of bankruptcy laws. This was meant to be kind of a patch holes in the code reform. And so what it does is it creates a subchapter of Chapter 11, a sub-process that's really geared towards small businesses. It's got some qualifications of its own that we'll chat about a little bit later. But for now, just understand that it's most akin to Chapter 11 in its process. It is a reorganization bankruptcy. Now, in terms of reorganization bankruptcies, it is very flexible and reasonably affordable, especially compared to Chapter 11. In common with Chapter 11 is that you still need some kind of reasonable expectation that the business is going to stabilize after the plan of reorganization and after the business exits bankruptcy. We'll talk about some potential, we'll look at some case studies later, some use cases for Subchapter 5. But the big takeaway is that if your business was, for example, floundering before COVID, if you were having some fundamental problems, maybe related to, disruption in your industry, maybe the internet or Amazon or whatever is eating into your business, and it was just becoming less and less profitable, and then COVID happened, and then you go into Subchapter V, and you propose a plan of reorganization that maybe you've got some good expectations that COVID is going to end and that is going to go away, but you don't address the fundamental problems of the business before COVID. Your plan of reorganization might fail. Subchapter V might fail. You might be forced into a liquidation, Chapter VII bankruptcy, or your bankruptcy petition might just be dismissed altogether, which can happen. Sometimes the bankruptcy court will just boot you out, particularly if, for example, you declare Chapter 11 and you don't qualify for Chapter 11 or Chapter 7, the bankruptcy court's just going to boot you out. Similarly, if you declare Chapter 7 and you don't qualify for it or Chapter 13, bankruptcy court's just going to boot you out. So that is a risk that you run. And so it's important when considering your options to be honest with yourself as to whether a reorganization, striking a deal with your creditors, is going to be enough to fix your business. Because if not, and if there are more fundamental problems that the bankruptcy itself isn't going to help you address or fix, you might want to look at a Chapter 7 process or something similar. And it's really important at that point to chat with a good qualified bankruptcy attorney who can go over your situation with you, look at your options based on what you qualify for, and really figure out a plan. Because going into this blind or just in a rushed manner isn't really going to benefit anyone. But Subchapter V, subset of Chapter 11, meant to be simpler. And there's a number of key differences here. The first is that ownership and management of the company typically remains with the business owner. In Subchapter V, it's presumed. You look at the code sections, there's the presumption that the business owner remains, the business remains with the owner as what's called a debtor in possession. You're the debtor, but you retain possession and control of the assets that could be used to satisfy the demands of the creditors later. So you're a debtor in possession, which in a sense means you're a trustee in your own right. You are holding your business and its assets in trust for your creditors and to some degree yourself. So you can be dispossessed of that business for cause. Some common examples of cause are fraudulent transfer of assets. If you are holding on to your company and urgently trying to move its assets out of the company and out of the reach of the bankruptcy court, which does not work, for the record. The bankruptcy trustee has a number of tools to claw back transferred property. But if you're trying to defraud the court, if you're chronically mismanaging the company and it can be shown that you're doing what's called spoiling the assets, if you're running the company into the ground, you can still be dispossessed of the business. But with the Subchapter V, you are presumed to retain control of your business. It takes cause to remove it from your possession, whereas it's largely discretionary in a Chapter 11. The key differences, point number 2, cost savings and flexibility. The disclosure statements in Chapter 11, as we talked about, are very onerous. I mean, it's a lot. Subchapter 5 still has disclosure requirements, but they're light by comparison. A brief history of the business, liquidation analysis, projections on the ability of the debtor to make payments under their proposed plan. Basically, you have to do the bare minimum to show that your business is going to emerge from bankruptcy solvent and capable of making the payments it's promising to under the plan. You don't have quarterly U.S. trustee fees, which, again, they can be huge in a Chapter 11, up to $250,000 per quarter or $1 million per year. Those fees for small businesses, because there's like a graduated schedule, they're not huge in many cases, but if you're a struggling small business, they add up quickly, especially if a Chapter 11 bankruptcy takes years. So, if you're on a Chapter 11 payment plan that lasts 5 years, those fees add up. With Subchapter 5, there's no such quarterly fees. Another nice feature of Subchapter 5, especially if you've ever dealt with the Chapter 11, you find this particularly nice. There's no creditors committee, at least not by default. One can be appointed, but they're not by default, and their appointment is rare in Subchapter 5, which is nice because creditors committee, it's a band or union of creditors who have all come together adverse to you as the debtor and are tasked with making your life difficult by proposing their own plans of reorganization, by um, by trying to down talk yours that you're coming up with, by scrutinizing your assets and proposing, well, why don't you do this? Why don't you do that? Why don't you just liquidate? I mean, creditors committees, for lack of a better term, they can be quite obnoxious. And so it's nice not to have to deal with one. Um, like like I said, you might still have to, but they're kind of rare in Subchapter 5s. Plans of reorganization, again, they're the cornerstone of Chapter 11 and Subchapter 5. One big difference is how you need to get consent, or whether you need consent. In Chapter 11, you need consent of certain classes of creditors who might be adversely impacted by a plan of reorganization to that plan, which, when mixed with another rule called the first priority rule, can make it almost impossible in some Chapter 11 situations, especially when you're a small business and your cash flow, even over a period of years, might not satisfy all the creditors well. You might not get consent in a Chapter 11 to your plan of reorganization. Some creditors might just downvote it, in which case your Chapter 11 fails. And if your Chapter 11 fails, again, you're either going to get converted to a Chapter 7, or you're just going to get booted out of bankruptcy court altogether. Fun example of a company getting booted out of Chapter 11 is the NRA. They just got booted out of Chapter 11 recently for very different reasons, but it's an example of how the court can and will exercise their authority in that manner. So just know that it can happen. But in Subchapter 5, you don't need the consent of your creditors, with a few limitations, but by and large, you don't need to get the consent of the adversely impacted unsecured creditor class. So Subchapter 5, if you can show that you can make the payment plans as contained in your plan of reorganization, and if you can show that the creditors are at least going to get more than they would in a Chapter 7, which again is a requirement for Chapters 11 and Subchapter 5, but if they're going to come out better on your plan of reorganization than they would in a Chapter 7, you can get the court to approve the plan and force the cram down, the write-off of those debts by the creditors without their consent. So that is a huge difference between Subchapter 5 and Chapter 11. And it lends itself to a much, much, much quicker and easier approval process for the plan of reorg. In Chapter 11, it can take years. I've been part of lawsuits for Chapter 11 here in Albuquerque in New Mexico for 3 years now, and it's showing no signs of ending. With a Subchapter 5, the time frame can be as quick as 6 months, maybe less. So I'll cover the timing in a little bit here, but just know that that's a huge difference, is that you can get a plan of reorg passed over the objections of your creditors. Again, payments from future revenue. Subchapter 5 has payment options that look a bit more like Chapter 13 in their structure. You can pay off the debts between a period of 3 and 5 years using all of the projected disposable income of the company. This is problematic for the same reason as in Chapter 13, which is that you can't really excel or get ahead during these payments. So if you're going to be making these payments under a plan of reorg for between 3 and 5 years, as part of some sort of compelled cram down, if you don't need to do 3 to 5 years if the plan of reorg stipulates for something less and the creditors consent to it. But if this is a non-consensual plan, you might be looking at 3 to 5 years, in which case, again, you're paying pretty much everything apart from your basic expenses and needs to these creditors. So just know that that can create some of the same problems as Chapter 13, to, primarily if you can't make the payments after a few years, something happens and the payments stop, you're not going to get a discharge at the end, because the discharge is going to come in a compelled plan of reorganization, the non-consensual one. The discharge is going to come after the payments have finished. And so if you don't finish the payments, there's no discharge of debt. And so you're in the same boat as you would in a failed Chapter 13. No absolute priority rule. Now, this is what I was talking about. In Chapter 11, one of the central rules is that senior creditors must be paid in full before junior creditors can be paid. Senior creditors, they can be, for example, if you have multiple liens on all of your assets of the business, they can just be older debts. The bankruptcy process involves categorizing creditors in a number of different ways, but the absolute priority rule in Chapter 11 requires that senior creditors must be paid in full before junior creditors can be paid anything. One of the reasons this makes plans of reorganization very difficult is because if there's not enough to pay the senior creditors anything, everything, and then to pay the junior creditors anything afterwards, junior creditors aren't going to consent to the plan of reorg. They just won't, because why would they? In Subchapter 5, the absolute priority rule does not apply. And you can confirm your plan of reorganization over the objection of unsecured creditor classes, so long as, again, all projected disposable income of your business is going to be, over a 3-year period or longer, such as the court may determine. 3 to 5 years will be applied to the repayment plan. Or, this is an interesting or, if the value of the property to be distributed under the plan in a 3 to 5 year period is not less than the projected disposable income of the debtor. So here's an example of how that plays out. If your business has property, assets, whatnot, that are expected to appreciate over that period of time to be worth more than the net disposable income of the company, you can pledge those assets instead. It's a little wonky doing a plan of reorganization with distributed assets or property, but it does happen sometimes. So it gives you a little bit of flexibility in figuring out how to pay these creditors, particularly if this is a compelled cram down plan of reorg. But again, the key takeaway, the simplified version of this, is the entire process of managing your creditors is a lot simpler in Subchapter 5. It's easier to retain counsel. The court doesn't need to approve you retaining or paying bankruptcy counsel as long as your pre-petition legal expenses don't exceed $10,000. Counsel in Chapter 11 is very difficult to retain because, once you file Chapter 11, that counsel ceases to be your attorney typically, and it becomes attorney for the Chapter 11 bankruptcy and the bankruptcy estate itself. It creates difficulties having that counsel represent you and your personal interests as the business owner. It's a little easier to retain counsel in Subchapter 5. The process is less strict. There's less of an oversight and approval process by the court. So as long as you're not racking up huge fees, especially pre-petition, you should be able to retain counsel even after the petition is filed without court oversight or approval. Plan exclusivity. This is a fun one. In Chapter 11, like I said, your creditors committee can band together and propose their own plan of reorganization that the court could approve over your objections as the debtor. If the court thinks that it is the fairest plan that is going to see to the needs of the creditors and still constitute a reorganization, the court can approve that plan instead. In Subchapter 5, only you as the debtor get to propose a plan of reorganization. It might sound minor, but it's pretty huge, especially, in conjunction with the fact that there's no creditors committee. It makes your life a lot easier. Now, not everyone qualifies for Subchapter 5. With COVID, you need to have debts below $7.5 million. That was originally $2.7 million in the 2019 Act, But in the COVID stimulus bills, sensing a pressing need for Subchapter V, they extended the debt limit to $7.5 million. That was supposed to sunset this year, but the latest stimulus bill extended that until March 27th of next year. So you have until then to get in under Subchapter V with the, with the higher debt limit. Now, again, one of the other qualifiers is that as within a Chapter 11, in a Subchapter 5, creditors cannot receive less than they would in a Chapter 7. So this is one of the biggest reasons we're seeing that Subchapter 5s fail, is that the people filing them aren't in a position to reorganize and should be filing under Chapter 7 and liquidating. So just keep that in mind. That's a qualifier for Subchapter 5. Now, on a step-by-step basis, you ask, how do I actually do this? The first step, each and every time, consult with a qualified licensed bankruptcy attorney. You're probably going to want to hire one to do the petition and the filings because it is complicated. It is so complicated to do these filings, and bankruptcy courts will reject them for minor issues of form. These are, the courts aren't forgiving in bankruptcy courts. If there's issues of form, they will reject the petition. You may or may not get your money back. You'll have to do extra work to refile the next time to cure the deficiencies. So just start with a good attorney. You move on to preparing the petition and the related documents. There's a number of documents you have to file with the petition: balance sheet, statement of operations, cash flow statements, tax returns, debt schedules, etc. The basic stuff that's going to be needed to evaluate your business and its debt issues and its potential for future solvency. Within 60 days of filing your petition, there's going to be a status conference. And at least 14 days before that status conference, you have to file a report with the trustee on your efforts made to create and to get consent for a plan of reorganization. The default that your assumption is that you are going to work with your creditors to get a plan of reorganization that everyone can agree to. And there's some important reasons for doing that. There's some benefits to doing that, but you have to at least make a good faith effort and then show to the trustee that you're doing it. Now, ultimately, you prepare and file the plan of reorganization within 90 days of filing the bankruptcy petition. I just saw something pop up. Do we have a question? No. Okay. So within 90 days, you prepare and file the plan of reorganization. Unlike with a Chapter 11 plan, this does not need to be approved by the creditors. You don't need their consent as long as it doesn't discriminate or result in them recovering less than they would in a Chapter 7. To confirm the plan, the court must find that either the debtor will be able to make the payments or there's a reasonable likelihood that the debtor will be able to make all of the payments, and there's appropriate remedies for the creditors if the payments are not made, which means, either it's a certainty that you can make the payments, or there's the reasonable expectation that you can, and the creditors are protected in the event that you suddenly fail to. After that, there's a discharge. Once the plan of reorganization is approved, there's the discharge. Now, this is why it's worth trying to get a consensual plan. If you get a consensual plan, and particularly if you can pay those creditors immediately under the plan, let's say you negotiate a 50% haircut of the debts and you can pay them all at once after the plan is approved, you can get a discharge then and there after the plan is confirmed, and you substantially consummate the plan. Without a consensual plan, if you're doing this over the objections of your creditors, again, you're looking at payments for between 3 and 5 years, unless you can pay the creditors off sooner under your proposed plan of reorganization. Somewhere between 3 and 5 years, paying up to all of your disposable income, and you don't get the discharge until those payments are made. So that's how discharge works. So your discharge might come right after the plan is confirmed if it's consensual, or it might come after all of your payments are made if it's non-consensual. Especially if it's non-consensual, but even if it is, you make your plan payments. So you make your payments over time, or you do the time distributions of property in lieu of those payments in accordance with the plan. Failure to make the payments will probably result in plan failure, particularly if there's no alternative remedies that'll satisfy the creditors and result in an alternative success of the plan. Your plan would fail. And if your plan fails, there's no discharge of debts. So again, that's the Chapter 13 trap we talked about. Now, real quick, we're going to look at some case studies, and then we're going to take some questions from everyone. Study 1. Paul owns a small but growing restaurant that was thriving before COVID-19, but experienced a total loss of income due to the public health orders. There was a period of time where restaurants were just closed. Then, was experiencing a substantial decrease in income because of capacity limits. Dine-in was banned for a while, and now it's subject to limitations. Maybe they've lifted those limits, but there's still mitigating things that business owners have to do with respect to COVID. And so the income is still hit, but the business was thriving before COVID. And Paul has every expectation that it'll keep thriving right after. But in the meantime, Paul owes substantial sums to food vendors, to his landlord, to credit card companies. Debts are about 220 grand. I mean, the debts are a lot, at least by the standards of a small restaurant that is still dealing with reduced income. He did not, this is key, Paul did not personally guarantee the lease or any other debts of the business, which means Paul did not agree to personally be responsible for and pay those debts if the business can't. What can Paul do here? This is a classic example of what Subchapter 5 is good for. His debts don't exceed the threshold, which is right now $7.5 million. He reasonably expects his business is going to recover, as it was prosperous before COVID and will probably be prosperous after. There's no reason to expect that it won't be. And he hasn't personally guaranteed any debts of the business. So his business filing of Subchapter 5 would totally address the debts. There's no one else on the hook that will be pursued for those debts in full if Paul goes the Subchapter 5 route for his business. That is a classic use case of Subchapter 5. Here's another example. Substitute Fiona for Paul. Same thing. She owns a small but growing restaurant. It's doing very well before COVID. Same thing. Total loss of income for a while. Reduced income now. She expects it's going to pick back up once the pandemic is over. But she owes substantial sums to food vendors, to the commercial landlord, to credit card companies, $300,000 in debts, and she did personally guarantee the lease and some other debts, which means that those creditors, if Fiona declares bankruptcy or otherwise defaults on those debts, stops paying those debts, the creditors can go after Fiona personally for the entire balance of the debt, together with their collection costs. They can go after Fiona's house, property, assets, bank accounts, etc. I mean, the creditors in those cases can do a number. And Subchapter 5 for the business would not deal with the personal guarantee. It might deal with the business's obligations, but not Fiona's. So the question is, what can Fiona do? And keep in mind, I get this a lot because, especially with small businesses, most small business owners are personal guarantors of the lease at a minimum. So I see this with landlords a lot. They will go after the guarantors in a heartbeat. COVID hasn't really made them any less likely to do that, frankly. So, what could Fiona do here? She could still use Subchapter 5. The debts don't exceed the limit, still the same expectation that a reorganization will work. Even though she's personally guaranteed the debts, the business filing isn't going to be enough. Fiona can also file Subchapter 5. And this goes back to the whole individuals can file Chapter 11 thing. Individuals can still file under Subchapter 5, particularly if their debts the majority of their debts are related to a business and they're engaged in a business activity. In this case, the carrying on of her business counts as a business activity. This is a little bit of a legal gray area because it's a little unclear in the wording of the statutes whether business owners individually can qualify for subchapter 5. Most reasonable readings of the statutes say yes. Case law, there's not a lot of case law on this, but there is some that's generally holding yes. So business owners use subchapter 5 in the same way as their businesses with a plan of reorganization. Again, the rule is as long as the business owner, or I'm sorry, as long as the creditor gets more in the subchapter 5 than they would under chapter 7, in this case for Fiona, they would be able, Fiona could use a subchapter 5. She doesn't have to liquidate, doesn't have to put all of her assets into a pot and have the creditor completely invade her, personal life and assets. If between Fiona and the business, they can come up with a plan of reorganization that addresses the debt, that would satisfy the courts. It's still tricky to do because you do have to look at Fiona's individual capacity to repay as a personal guarantor, but it is a way to deal with the personal guarantee in a way that doesn't require a full Chapter 7 liquidation. Now, we've got a question here. How did the man in the first example even manage to not personally guarantee the rent, etc.? Great question. I'll be honest, in my experience with commercial landlords, especially in Albuquerque, New Mexico, and in the rest of New Mexico for that matter, they almost always insist on a personal guarantee, which I'm sure as a small business owner you've seen. There are some benevolent landlords that do not do that. I have come across a few, bless their hearts, I love them, because they are not, they are sharing some of the risk with the business owner, that if the business fails, they're not going to drive the business owner into the poorhouse by enforcing the personal guarantee. So there are landlords out there that don't insist on personal guarantees. You just have to work to find them. Now, the last use case I'll go through. Jeremy owns a boutique retail store in Nob Hill. He'd fallen behind on lease payments before COVID-19, and his business was on the decline. But when COVID-19 hit, he received substantial assistance through PPP loans, tax credits, and so on. His landlord probably agreed to some kind of deferral where back due payments were added on to the end of the lease. This was a very common approach with landlords, at least at the start of COVID. They don't really do that much anymore, but when COVID was new, landlords were doing this a lot because they didn't know how long the pandemic would last. They just took the payments that were owed in the moment and then stacked them onto the end. So maybe, Jeremy, and there's a typo in this slide here where it says Paul, but whatever, we're talking about Jeremy. Jeremy managed to keep the business going throughout COVID, but now he's in a position where the economy is rebounding, things are opening up, his business isn't rebounding. He needs some kind of relief. What should Paul do here? Or I'm sorry, what should Jeremy do here? I'm getting mixed up with names. This is what happens when I write my own use cases. Jeremy probably isn't going to benefit from subchapter 5 because, like we've talked about, it's a reorganization bankruptcy, and you need to be able to show that under the plan of reorganization, your business is going to be able to emerge solvent and be able to make its plan payments. So, because he had these issues before COVID, and because these issues are fundamental to his business and he's not proposing anything in the plan of reorganization that's going to fix those, subchapter 5 is probably going to fail just like a chapter 11 would. Jeremy's probably going to want to look at a chapter 7 liquidation. Sad to say, but he's probably in that position where if the business is going to fail, it's going to fail, and chapter 7 might be the way to go to deal with the debts of the business so that the creditors get paid something and then the debts are discharged and they're not hounding Jeremy till the end of time. Especially, this might be a situation where Jeremy and his business do a joint chapter 7, and by that I mean they each file their own, one for the business, one for Jeremy. That way, if Jeremy was a personal guarantor, for example, chapter 7 will eliminate personal guarantees in most cases, typically all cases. So yeah, this might be a chapter 7 example. Yeah. So, big takeaway, utilize your resources. Every business owner situation is unique, especially when it comes to bankruptcy. I have never seen two businesses that are exactly alike when it comes to bankruptcy. Between means testing, the nature of assets, what the business owner wants to do. Do they want to keep the business? Do they want to keep this asset, that asset? Do they want to keep the relationship with the creditor by affirming a certain debt? There's a lot that goes into this. So chat with a good bankruptcy attorney. If you're not sure where to start, reach out to your local small business development center liaison, to the SBDC. Not only do they have great internal resources, advice and counseling for small businesses, but they have a great wealth of network connections. So if you need a bankruptcy attorney, there's a good chance they can point you in the right direction. Honestly, SBDC, with its no-cost counseling services, it's a great resource, especially to start with, to kind of figure out what way you need to go. They can also help you look at loans that might serve as an alternative to bankruptcy. They can help you with loan applications in some cases. I mean, use your resources. Questions. I've been accepting questions throughout, but was anyone saving their questions to the end? I'm happy to answer them.
No, that's a lot of information you have there, Ian. And I guess the big thing is deciding when you're at the point where you would consider bankruptcy. Because I know sometimes some other federal funding and stuff comes out, but I think consulting an attorney would probably be, or your SBDC advisor would probably be the way to go if you're even thinking you're not quite there yet. Is that kind of your takeaway?
This is one of those cases where it varies by business owner, but a good rule of thumb is if you're at the point now where you're a month or two behind payments and behind on payments, and you're not looking like you're going to catch up anytime soon, if ever, you probably should have already consulted a bankruptcy attorney, but you might go that way now because uh, ideally, if you're going to declare bankruptcy, you want to do it in a well-reasoned and thought out and calculated way before you're at the point where you are so far behind you don't have anything to pay the bankruptcy attorney, you don't have anything to put into the pot for creditors. The trustee starts looking at your last few months' expenses to see, well, did you spend this on anything frivolous if you're fully insolvent? I mean, sometimes it's best just to be proactive. And if you know that there's no light at the end of the tunnel for your business, or if you know that there is a light at the end of the tunnel, but I need this reorganization or these debts are going to crush me before I can get there, be proactive. Chat with the bankruptcy attorney. Then it might save you a lot of headache and actually might let your business succeed where it would otherwise fail if you dig yourself too deep a hole. We've got another question. It sounds as though the high end of Chapter 11 quarterly payments are around $250,000. What's the low end for smaller businesses? That's a great question. And I don't remember, but I have the chart. So let me just look at the chart. Give me just 1 second to pull up the quarterly fees. They can range all the way down to $250 a quarter at the low end, depending on the total amount of disbursements made. So the quarterly fees can be relatively low, especially for small businesses. They go up from there to 0.4% of quarterly disbursements, up to 0.8% of quarterly disbursements, up to 250 grand. Depending on the total number of disbursements. So it's not like small businesses are paying 250 grand. Their fees might be quite low comparatively, but it's still a fee that you have to pay to the trustee on top of everything else. Like I said, creditors committee fees and the payment plans themselves, like the payments.
Yeah, on top of everything else. Wow. Last call for questions. We're running out of time, and I want to thank everyone for attending today because, again, all this information that NMSBDC is giving everyone is so relevant and valuable. So if that's it, we're going to dismiss all our attendees for today.
Thank you all.
And thank you again. We will see you next time. Bye.